July 2, 2018 by Charles Kuffner. We go from here. The federal judge in a landmark bail lawsuit against Harris County set new ground rules for law enforcement and judges about pretrial release for thousands of low-income people arrested on low-level offenses in a revised injunction issued Friday. The order prohibits the county from detaining a poor person in instances in which a person with money would be allowed to pay and get out of jail. Specifically, qualified poor people charged with certain offenses, such as drunken driving or writing bad checks, will be permitted to leave jail immediately and return for future appearances. However, the finding also gives judges 2 days to make a bail determination for people arrested on more serious offenses or who face holds or detainers that would prevent them from being released. The county will have another chance to argue the full case when the 2016 lawsuit goes to trial on the merits on deck. 3. However, county officials could opt to settle the case, something both sides have indicated they would like to do. In 2 years litigating the case, the county has hired dozens of lawyers at a cost of $6.7 million. Precinct 1 Commissioner Rodney Ellis, a longtime criminal justice reformer who has backed the lawsuit, said Friday's decision affirmed the court's finding that there are no legal or moral grounds for the unconscionable and futile defense of a two-tiered system of injustice that favors the wealthy and punishes the poor. The county's indefensible money bond system routinely violates the constitutional rights of poor defendants and forces people to languish behind bars simply because they cannot afford bail. There is no disputing this basic fact, Ellis said. Countless families have been torn apart and lives have been ruined by an unfair bail system that denies pretrial liberty and basic constitutional protections to poor defendants. The lawyers defending the county called Chief U.S. District Judge Lee H. Rosenthal's order, an excellent beginning for a settlement. The county remains committed to a settlement that maximizes the number of misdemeanor detainees who are eligible for prompt release from jail without secured bail, that provides due regard for the rights of victims and protection of the community and preserves the independence of the judiciary, said Robert Sword, first assistant to Harris County Attorney Vince Ryan. See here and here for the background. It's hard to remember because this has gone on for so long, but the entire fight so far has been about the preliminary injunction, which is what is being finalized here. This is the order to define what the county can and can't do while the lawsuit proceeds. Litigating the case on the merits could take years more, and cost many more millions. So if the county really does see this order as a good foundation for a settlement, we should all be glad to hear it. Of course, that is mostly up to the misdemeanor court judges, who are the defendants and who have refused to budge throughout. Perhaps Commissioner's Court can put some pressure on them, though outside of Commissioner Ellis they've been part of the problem, too. If you truly want to see this come to a just and cost-effective end, the answer is to vote those judges out in November. Ultimately, we get to decide. Fritz has more.